my name is Jennifer Hegg. I am a court services officer for Landlord Tenant in Atlantic County. I will take you through the process of filing a complaint, general case management, settlements, trial, and post-judgments. What is Landlord-Tenant Court? Landlord-Tenant Court is for landlords to evict their tenants for non-payment of rent or for other reasons under New Jersey state law. A landlord-tenant action is for possession of the property only. There are no money judgments. Money is only relevant as it's related to what a tenant owes and will need to stay in the property. To evict a tenant, a landlord must get a judgment of possession. Judgment of possession can be obtained either by default or a trial in front of the judge. When filing a complaint, you must determine whether a landlord and tenant relationship exists. If there is no exchange of money, then this is not considered a legal landlord-tenant relationship. To have a tenant removed in this situation, you'll have to file what's called an ejectment. To do so, you'll need to file a writ of execution to remove an illegal tenant. First, you need to determine why you are seeking an eviction. Is this non-payment of rent or holdover? A holdover is filed for any other reason than non-payment of rent. To file a non-payment complaint, a landlord must include the following: a verified complaint, a copy of the lease, copy of the registration statement from the local municipality, tenancy summons and return of service, certification of lease and registration statement, and a landlord case information, LCIS. There is a $57 filing fee for one tenant and $12 for each additional tenant. To file a residential holdover, a landlord must also provide all required notices to the tenant. For example, you would notice the tenant that you'd like to terminate the landlord-tenant relationship and not renew the lease. Or the tenant may have lease violations, such as damage to the property or unauthorized occupants. What happens after a complaint has been filed? After a complaint has been filed, the court will issue a docket number and the tenant will receive notice by mail. A copy of the complaint will be posted on the door of the residence or commercial property. If there is a deficiency in the documents that have been filed, you will have 10 days to correct this deficiency or the case will be dismissed. If all dockets are properly filed, you'll be issued a court date. What happens on the day of court? The judge will make various announcements and then call the case list. Each party will answer ready landlord or ready tenant. If the landlord fails to appear, the case is dismissed. Then the tenant is free to leave and will not receive anything additional from the court. If the tenant fails to appear, then the case is defaulted and the landlord may file the warrant of removal. If both the landlord and tenant have appeared, the case will then go to a settlement conference. A settlement conference is done by the landlord's attorney and neutral court staff. If both parties settle their case, then the settlement will be placed on the court record with the judge. Both parties to a case are required to be present when the settlement is placed on the record. A copy of the court order will be provided to both parties. If the case does not settle, then the judge will have a trial. Tenants have a right to a trial and not required to settle their case or accept a proposed payment plan. A tenant may want to proceed to trial due to damages in the property not corrected by the landlord and may raise the Marina defense and request what's called a habitability trial. A tenant must post all rent due and owing to proceed with a habitability trial. If a tenant misses their court date, they can file a motion to reinstate their case or order to show cause application explaining your situation to the judge. After trial post-judgment, when the judge grants judgment of possession, the court is granting the landlord the legal right to possession of the property. After judgment of possession is entered, the court may have a warrant of removal served by a civil court officer. The notice will be posted on the door of the rental property, and a warrant may not be issued any earlier than 3 days after the judgment of possession. After posting the warrant of removal, the officer may return to the property a second time, requiring the tenant to vacate and changing the locks. After the lockout, the tenant will have 3 days to pay all back rent, courthouse costs, and fees to be restored to the property. After the warrant of removal is placed on the door, the tenant may come to the courthouse to file an emergent application. The first application is an order to show cause. Tenants can file this application if they feel they should be allowed to stay in the property. If granted, you will receive notification from the court that the application was granted or denied. If granted, the judge may issue a new court date. The second application is order for orderly. This will allow for more time in the rental premises, up to 7 calendar days, for a good reason. The third application is the hardship stay. This is filed due to unavailability of other housing accommodations. The hardship stay cannot be granted for more than 6 months of entry of judgment of possession. You will have to pay all rent and proper costs to the landlord. A copy of a court order will be provided to all parties stating the outcome of the case. If you need any additional information, please go to the civil window at the courthouse where your case was filed, or online at njcourts.gov. You may also contact your local ombudsman's office if you need assistance filling out forms. If you need legal resources, court staff keep a list of agencies that may be able to assist with temporary shelter or legal services. Please contact your local civil division for a list of local agencies. Thank you for your time in viewing this video. I hope it answers questions you may have about the landlord-tenant process.